Good morning, everyone, and welcome to today's presentation on criminal advocacy. On behalf of the chairperson of the Judicial Education Institute of the Turks and Caicos Islands, I'd like to welcome you to today's seminar. Presenting today would be the Honorable Mr. Justice Ian Morley, King's Counsel, who joins us from the Eastern Caribbean Supreme Court. We have also with us today Mr. Oliver Smith, King's Counsel, and Ms. Lara Maroof. We thank them for so generously sharing their time to provide us deep insights onto the topic of criminal advocacy. So beginning today's presentation would be Justice Morley. Justice Morley, we welcome you.
Right, well, thank you, Mr. Emanuel. Good morning to the TCI, to those in the room and those who are online. I have some materials. I've got a PowerPoint and I've also got an example of a skeleton argument. Mr. Emanuel, can I check with you? Have you distributed any of that material?
Yes, Mr. Morley, certainly. We have distributed the problem question and the PowerPoint. You can share it, or you can let me know if your preference is for me to share it to the screen.
I will try sharing it and we'll see how we go. So let's bring it up.
Excellent.
All right, so I'm hoping that you can see there the first slide, submissions as oral and written criminal advocacy. Is that right, Mr. Emanuel?
Yes, we can see it, certainly.
And if I click here, I'm assuming that we go to the second slide. Advocacy can be taught up to a point. Is that right?
Yes, it is.
All right, super. Well, let's start. Thank you very much. I'm going to address you for, in all, about 40 minutes, 45, thereabouts. And then there'll be time for a few questions. And there's a PowerPoint, I think it's about 10 slides. There's also a skeleton argument example, which we will go through together. And the brief for me has been to discuss submissions in criminal advocacy, oral and written, with, I think, the most attention paid to written submissions. I think we're all used to advocates being on their feet, talking. But we will have some thoughts about oral submissions as well as written submissions. Now, advocacy training is something that's been going on certainly through London for about 30 years. I was reflecting on it earlier today. I think the great gathering took place in January of 1994 over in Gray's Inn. And on the back of that, the Australians brought to London advocacy training as a concept, and they borrowed it from the United States. And since about 1994, it's gone worldwide. You'll find it in all the common law jurisdictions. You'll find it also in formerly communist jurisdictions. And it's growing in its presence in civil law jurisdictions. I know there's quite a lot of activity in South America at the moment. So advocacy training has become a big thing. And it used to be, as Andrew Mitchell will remember, you learned advocacy by a mysterious process of osmosis by sitting alongside your pupil supervisor. And there was no science or art to it. It was just, it enveloped you. And you either got it or you didn't. But from 1994 onwards, there was the thinking you can teach it up to a point because it is a skill. And like any skill, you can teach a skill. You can teach people to play the piano up to a point. They can all play four Elise if they're given enough time and encouragement and a few pointers. Four Elise, a little piece by Beethoven. You can do it creditably well. You can make an appearance in front of friends, relatives, family playing four Elise, and everybody will murmur their approval. It can be note perfect. You may not become a concert pianist in the end, but you can do a pretty creditable performance. And advocacy training simply aims to deal with a creditable performance with regard to you in court. Now, I've just seen that the screen has changed, and I'm looking at Miss Maroof. Has your screen changed, please?
Oh. No, I have you in one corner. Well, no, I did have you. Now I do have Lara.
All right, so let's
and
just...
now I've got you back.
Right, I don't know what's happened there. I've never seen this happen before. I'm going to stop the share and start it again. Thank you, Mr. Mitchell. Are we back to the screen share?
Yes.
Yes.
Okay. And if I go to the first slide, do you have the first slide? Submissions as oral and written advocacy.
Yes.
Okay, all right, so we're back in business. Thank you very much. Right, so I'll go back to the working slide. Advocacy can be taught. So now the thing about, if you do a creditable performance, a bit like playing Four Elise on the piano, in advocacy, that's a big deal. And people should ring church bells up and down the length of the country, because an error-free performance in court is fairly rare. But the theory of advocacy training is that we can teach a notionally error-free performance, but we can't teach talent. Whether you've got talent or not, well, you'll find out as the years go by. But we should be able to help you not make terrible errors, huge blunders, and fall into giant elephant traps. So that's the modest ambition of advocacy training, and part of this presentation. And my own history is I've been an advocacy trainer with the Inner Temple, where I'm a bencher, and I've been doing that for 30 odd years. And I've traveled all over the world teaching advocacy. The background to any advocacy in court, you'll know, of the 3 E's. That is to say, ethics, the bedrock ethics to your work in court. Never mislead the court. You know all about that. Don't tell lies, even small ones, teeny weeny, insy bitsy ones. Don't tell those, because if you do, the ground should open up and you should be swallowed and never seen again. And before you're swallowed, you should also be shot. So shot and then swallowed by the ground. Never tell a thing in court that you know isn't right. It's not true. You know all about this. It's very important if advocates tell lies, even tiny ones, like I was a bit late to court because I was struck in traffic when in fact you were upstairs having a coffee and you couldn't be bothered to come down when the tannoy brought you to court. Tiny little lies, no, must never be allowed. The second ethic, of course, is never be sharp with your colleagues. You are colleagues. It's an honorable profession. Please always behave well with one another. You don't try to get ahead of one another by bamboozling, obfuscating, tripping up, saying you'll do one thing, doing another, saying you'll not do a thing, then doing it. You behave honorably. And the reason for that is the tribunal will work out if you have not been behaving honorably and sensibly and you're being sharp with your colleagues. And tribunals don't like that. And you ultimately have to persuade the tribunal, and they, as an institution, whether they're a jury or they're a judge or there are a number of judges in the Court of Appeal, they will be very wary of you if you're being sharp with your colleagues, and they will not lend their ear to you in the way that you want them to in order for you to be persuasive. And that is your job, to be persuasive. So if you've got authorities and you've got a skeleton argument, you've got a submission you're going to make, please ensure you give your colleague opposite time to see the material. You don't sort of slip it out as you stand up to make your submission. That's not the way it's done. And tribunals don't like that at all. So don't ambush your colleagues, give them some notice. If you've got a good point, it's a good point. You don't have to ambush your opposition in order to make a good point. And then the third ethic is you want to think like the tribunal, not like the client. You're the one with the training. It's not your role to go into court, be a gunslinger and shoot the place up and basically shoot at whoever the client says, have a shot at that person. Your job is to try and persuade the tribunal of the client's position, whether you're prosecuting or defending in criminal work. You don't persuade a tribunal by just being a gunslinger shooting people up in court. So what you want to do is you want to be thinking like the tribunal. You want to be asking yourself every time you open your mouth in court, what's the effect of what I'm doing? What is the tribunal making of what I've just done in court, or what I've elicited, or what the witness has said, or how this submission is going across? You want to be thinking about the impact you're making on the tribunal that's listening to you, not thinking about what the client's thinking, but how effective are you as an advocate persuading, and therefore you're thinking like the tribunal. You're thinking, yeah, how does this come across? If I was listening to this myself, what would I make of it? Would it be gobbledygook, or would it be reasonably intelligent, a reasonably good point? Would I be persuaded by what I'm saying? And as part of your presentation of your argument, thinking like the tribunal, maintaining proper ethics, you want to observe the 3 I's. This comes as a surprise to some advocates. Invisibility, irresistibility, and integrity. Invisibility, what does that mean? Well, the case is not about you. It's about the argument. It's about the circumstances of the case, about the witnesses, about what happened. It's not about you. It's not an opportunity, or shouldn't be, for you to grandstand, strut around the court like an enormous tiger, as you think yourself to be in your mind. But in fact, a tribunal seeing a tiger, or a person thinking they're a tiger strutting around the court, will more often put them in the category of being a small tabby cat wandering about. Because the tribunal is looking to try and decide the issues, and doesn't want personality contests in the courtroom. So you want to be invisible behind the argument. And the argument needs to be the second I, it needs to be irresistible. You're looking for a quality of presentation which makes what you have to say seem obviously right. Not sort of a big argument, a big tub-thumping event, but something which seems obviously right, pretty obvious. And when you find the irresistible, obvious argument, then the case runs itself. You naturally arrive at the winning position, and everybody wonders to themselves, well, why on earth was there ever an argument about this? It was obvious what the answer should be. To get to that, to get to the irresistible argument, takes a lot of skill. It looks easy. It's a bit like playing the piano at concert level. It looks easy, but it's not. It takes a lot of skill, experience, and a bit of cunning as well. And as I say, none of that skill or experience or cunning is apparent in the irresistibility of the argument. It just looks like what you're having to say is right. And it's the highest mark of respect for an advocate if the jurors all go out, or the judge goes out and says, well, that was obvious. I don't know why we had an argument about that, but I've no idea who the advocate was, can't remember, because all they will have been persuaded by and will remember, as they should, is the argument, and not you. You are invisible behind the irresistible argument. And while you're making the irresistible argument invisibly, you must ooze integrity. And we all know this, but there is sometimes an assumption that when you wear the gown, that you automatically are bestowed with integrity. Don't blow it. Don't waste the standing of the gown by then, because you're relying on the integrity that's implicitly within it, you start behaving like a gunslinger. So the reason for maintaining integrity, of course, is so that the tribunal, when they're listening to you, recognizes that you're a reliable person, an honorable person. You're not taking advantages over your opposition. You're not telling lies. You're not simply the mouthpiece for the unthinking client. You are a person who's trying to help the tribunal with working out what the right thing to do is within the case. And that takes us to the next slide, which is persuasion. Because as you are trying to help the tribunal as a person of integrity, invisibly and irresistibly, to reach the conclusion that you are inviting, which is the one which is your proposition, you are trying to persuade. And that is the classic word which governs an advocate's standing. Your job is to persuade. It's not to be in court and make a lot of noise. And there are a few who do that. I've seen them, and I'm sure you have as well. It's your job to persuade, to take intelligent points, to concede points which aren't intelligent, to make the best points. And when you are trying to persuade, that rubric is you try to get the tribunal to really, really, really think about your case. And I put in 3 reallys there because I'm trying to emphasize, often as an advocate, you will have a hopeless case. Your job is, and you're doing it well, if you're getting the tribunal to really, really, really think about whether your case is as hopeless as it may seem. If your client is insisting that their alibi is that they were on the planet Zog and therefore couldn't have committed the murder, and that's what your instructions are, well, you're doing a really good job if you've got the tribunal really, really, really thinking, well, maybe, was he on a planet called Zog? Now, they may conclude at the end of the day, of course he wasn't, but if you've got them really, really, really to think about it, you're doing a good job. And what you're doing always is you're applying the test. What's the test? Well, if you're in criminal work, prosecuting, the test is you have to prove your case beyond reasonable doubt. You have to make the tribunal sure. And if you're defending, you're raising reasonable doubt. You're exploring weaknesses in the Crown's case, which prevents them from being able to prove the case so that the tribunal is sure. So you are weighing everything you do against the test. It's not just a philosophical wander about what you might think about this, that, and the other. It's all weighed against what's the impact of what I'm saying on the test. Does it affect whether a case has been proved beyond reasonable doubt? Does it affect whether there are weaknesses in the case? Does it suggest that a person weighing the case cannot be sure of certain facts? So you're always weighing whatever you say against the test that is being conducted in the courtroom. It's not a wander around, well, I wonder if, and what do you think about? It's all about, well, if the following is right, then doesn't that suggest that the prosecution have not proved the case beyond reasonable doubt? If the following may be right, if you can't rule it out, does that not suggest the prosecution have failed to prove the case beyond reasonable doubt? Or if you're prosecuting, you'll be saying, and of course, this witness was terribly reliable, and that would suggest you could be sure of the witness, and sure is what we're inviting you to be, because we say you can be sure of the prosecution case is proved beyond reasonable doubt. So you're always weighing what you are getting the tribunal to really, really, really think about against the test as you advance invisibly your irresistible argument with punctilious integrity. We go to the next slide, fidgeting. Well, some of you will do this. I recommend, as I think anybody who's done advocacy training will know now, you all see yourselves on video, because when you do, if you've not done it before, you will be horrified. You will see you're doing things you weren't aware of. You'll be moving pens around, papers around, your hands will be all over the place, you'll be wobbling about in your feet, you'll be scrunching up over the lectern, you'll be touching your nose, touching your ears, you'll probably be doing ums and ers and ems, which I've just done a moment ago. And it's important that you are aware of these things so that when you present your oral submissions, when you present your questions, when you present your argument to the court, you are aware of how you look and whether you are engaged in distracting fidgets. And there are ways in which to avoid doing that. The best one that I've come across is furiously wriggle your toes. If you furiously wriggle your toes, you will automatically stop moving your hands, your papers, your pens, your wobbling, your scrunching, and all your ers, and ems, because you are concentrating on wriggling your toes, which can't be seen Nobody can see the toes wriggling, but it stops all the fidgeting, and it's a very tip-top tip. And whilst you're addressing the court, ums and ers, they very often fill in silence, and don't be afraid of silence. In order to pick up your thought as to what you want to say next, have worked out what you want to say next, don't fear silence, relish it. Stand like a rock as the winds blow and the seas ferment around you, but stand and don't fidget and, as it were, run for cover with ums and ers. Silence is fine. And give yourself a moment to gather your thoughts as you then proceed to next slide. Which is oral submissions to the judge. Now, I'm not dealing with questioning witnesses. I'm not dealing with opening speeches, closing speeches to juries. I'm dealing with oral submissions to the judge. That's my brief for today. There are some obvious points which you will know, but they're always worth repeating. The first is deference and politeness. That's, as it were, goes without saying. There are sometimes advocates who get it wrong, but it's my experience most advocates know all about this one. Deference and politeness, it's not just there, as it were, to big up the judge and make the advocate feel small. It's there so that there's a process where disputes are resolved. If people didn't have faith in the court process, what would happen is they would solve their disputes by hitting each other with sticks. And we're trying to avoid that. So we have a structure to how we deal with judges in the courtroom, and the watchword is deference and politeness, but don't overdo it, but keep it in mind. The judge is the arbiter in the courtroom with the authority. Next point, this is sometimes strange for advocates. Judges are not stupid. All right, some judges are cleverer than others, but everybody who's on the bench has a measure of intelligence. Please always remember that. They've got a lot of experience. They understand a lot about people. They wouldn't have been made judges if they didn't know a thing or two. And sometimes it is frustrating for an advocate when they've got a point they're trying to make and they just think the judge is stupid. Well, be careful. Don't show the judge you think the judge is stupid, because that tends to then set up a conflict between you and the judge, and it tends to set up what is a little bit later on in this slide, loss of face. Who's going to lose in an argument where it's you versus the judge, and underlining the propositions you're putting forward is you are giving the impression you think the judge is stupid. Well, the judge is possibly therefore facing loss of face in the event that they don't quite follow what you're saying, which may be your fault, but it then accentuates whether it looks like the judge is stupid. And they will be instinctively against you. And if that's right, because they're people, keep it in mind, judges are people. I know it may come as a surprise to some, but they're people. Always be alive to the fact that you want to help your judge. You want to help. You want to assist. You want to show the answer, not tell. You want to be alongside the judge, offering a view of the battlefield, not standing in front of the judge saying, over my dead body. You are trying to help. And if you help and you support a judge, even when the judge hasn't quite grasped the argument and is looking a bit stupid, if you help the judge not to look daft, then you will have the judge's ear. The judge will be very grateful for ensuring that the judge doesn't look daft. And now you've got the judge's ear because you've been helping. And because you've been helping, the judge is listening. And if the judge is listening, you can be the P word. And the P word is persuasive. And that is your job. So additionally, when addressing a judge, it's your lordship, your ladyship, your honor. It's not you. as you may all know, some advocates, particularly the youngsters, make a few mistakes about that. It gets a bit personal when you come out with the word you. Addressing a judge, generally speaking, a point only needs saying once, but watch the pen, because the pen will tell you whether the judge has got the point. The judge generally is making a note. Make eye contact. If the judge isn't making a note, you'll know from the eye contact whether the judge has got the point. You generally only need to make the point once. There's a habit in criminal cases of saying things 3 times, 4 times, 5 times. Because you're in front of a jury, you don't need to do it with the judge. But make eye contact, watch the pen. So make sure that the judge has got the point. You want to help with the law. Judges don't know all the law. Again, it comes as a surprise to many folk. They don't know the law. They've got a pretty good idea where to find it. They've got some pretty good ideas as to what it is, but they don't know it all intricately. So when you start referring to the law, help with it. Bring the judge to the relevant bit. Wait for the judge to catch up. Make sure the judge is at the same spot that you are at when you start to read whatever the ratio of a case is or whatever the legislation is. Help with the law rather than just blather it out in staccato machine gun style, expecting that the judge knows all about what you're talking about, because judges don't know chapter and verse everything that's in the legislation and the case law. Make sure that before the judge you concede bad points. Why? Because it makes you look intelligent, reliable, full of integrity. And if you've got integrity and you're intelligent, reliable, the judge is listening to you and therefore is waiting for your good points. So when you make your good points, the judge is listening. And one of the important things to do when you're addressing a judge is make the best point for the other side and then answer it. Right? So you can demonstrate that you have an understanding of the other side's position, and then you explain why the other side's position is flawed. As always, don't be personalizing it by, I think this is the answer. You will be using the expression, a nice little rubric, the court may think, your lordship, your ladyship, your honor may think. You use that expression rather than I think. And that is something which I think a number of advocates lose sight of. Always put the thinking into the mouth of the court rather than it being your personal opinion. Now, you've been talking to the judge, all right? You've got a written submission which is now going to support what it is that you are submitting, and we are going to talk about written submissions in criminal advocacy, namely the writing of a skeleton argument. And I'm just checking, are we on the slide, Mr. Emanuel, for writing written submissions in criminal advocacy?
Yes.
Okay. Can somebody tell me, please?
We are.
Just a small
All
area.
right, thank you. So we're on the right side. That's good. So it's all working. Now, a skeleton argument. These are documents of some importance, and they're not much used in the Caribbean region, and we need to get to see more of them. A skeleton argument is an overview of the case. In the opening paragraph, you want to nail what you're asking for. The overall structure of a skeleton should be short. It should be short, laying out the heart of the argument with references to the relevant law, and also where various bits and bobs can be found in the case papers. So it's important that it's not a tome, it's not a treatise and everything that could be possibly said about something. You want to get to the heart of the point. It needs to be a relatively short document which covers everything, but it doesn't become some academic exercise in erudition. You want the skeleton argument to be effective, and in order to be effective, it has to be consumable. judge has to be able to consume it and understand it and absorb it. And it's difficult to absorb and understand long documents. So you want to try and keep it short and to the point. And the skeleton should provide a short summary of the facts as you would wish the court to find them, and a short summary of the law as you suggest is how it stands, with clear references to where the law can be found, and briefly how you suggest the facts apply to the law. So you're weaving, having nailed in your opening paragraph, you're weaving the relationship between the law and the facts. So keep in mind, you want to enunciate in short form the facts as you suggest they are, as they've been established during the course of the trial. And then the law, as you suggest, is relevant. And then you want to blend the two as to how you suggest the facts fit the law. And all of this in a short document that is designed to cover your best points, and also dealing with the best point being made by the other side. And we go to the next slide, using a skeleton argument. So what do you do with it at court? You filed it, the judge will have had a look at it. Well, you use it as your map. You don't just read it out. You refer to it, you read bits of it. You may read the whole thing out, but you elaborate on it as you are developing your argument. And you use it as an anchor. It's a map around which the submission is then made before the court. And you quote from it as you proceed with your written argument. And so, as you're on your feet, you begin your argument by capturing the bullseye point in a neat opening sentence, making clear what you seek and why you should win. You then identify, as I've said, what you say are the facts, pointing out where you've mentioned them in the skeleton. You now develop where you say there is an argument with your opponent on the facts and why you should win it. And you explain how you suggest the law fits the facts as you suggest they are. Identify where the arguments lie and explain why your argument beats the other side, reminding the judge of what is in the skeleton. So you're working your words as you utter them with the words as you have written them. And most important, say what is the best point for the other side and answer it. So what I'm trying to convey in this discussion is the importance of a double act between what you say and what you've written. So it's not just reading out the skeleton argument, and it's not talking without referring to it, thinking that the judge has read it. So you want to blend the two things together, your oral submission along with what you've written, and the effect is quite cementing. It carries a weight, it carries an impression that there's a lot to what you're saying, if you're not only saying it, but it's written down and is comprehensible in written form. So what we're going to do now is we're going to have a look at a skeleton argument, and we're going to have a look at a case called Wayne Beeman. I teach advocacy skills. I have been for a number of years over at the famous Keble College advocacy course each year, and Keble in August, the end of August. And there's a problem we use over there now called Beeman. We used to use a problem I wrote, but we've now got a new one, which has been written by the late Alistair McCrett, the former Recorder of Westminster. And what I'm going to do at this stage is I'm going to stop the share, and I'm going to go to the document, which is the Beeman skeleton, which I have prepared for your entertainment. Let's have a look. Here we are. Now, do we now have on the screen Rex against Wayne Beeman, Mr. Emanuel?
Yes.
Thank you. Now, we're going to read through this document together. It'll take a few minutes. It'll carry us up towards 11 o'clock. Now, here is a decent example of a skeleton argument. And the below was written some years ago by a young participant, his name has been changed, in the famous Keble College International Advocacy course run annually by the Southeastern Circuit in Oxford It is a good skelly. That's the word we use amongst us judges and barristers, members of the profession. It's a good skelly, although it's been a tad adapted by me. Without detailing every facet of the case, which will just take too long, it's quite a complicated case, Beeman. The factual scenario is broadly, in a dark early February evening, on a tip-off, 2 police officers, Sullivan and Griffiths, attend an unoccupied drug den, it's called Flat 6, and find heroin in wraps at 28% purity, scales, and a tin of money. While there, someone tries to enter the flat using a key. PC Sullivan sees the person open the door and gives chase, briefly losing sight. Outside, there are 2 men, with one passing something to the other, both running off. PC Sullivan chases the person he believes was the person at the door, being Wayne Beeman, with previous convictions for drug dealing, and near him on the ground when he's caught was the flat key. PC Griffiths chases the other, who gives the name Derek Horrobin, on whom there is nothing incriminating, and releases him, having noticed his description, though near him is found heroin, whose packaging and purity are consistent with the heroin coming from the flat. A witness named Chris Simon, who's a dubious character, a drug addict, in the area to buy drugs, says the person Sullivan was chasing was Beeman, who he calls B. And Beeman's thumbprint is found on the dealer's money tin in the flat. And the defense is Beeman was going to the flat to buy drugs. Horrobin suddenly appeared, being chased by Sullivan, pressed the key on him. Both ran, as some do when police appear. Beeman threw away the key, was not the person trying to enter. The drugs near Horrobin show he was the dealer, which had not been passed by Beeman to Horrobin, who better matches Sullivan's first description, while Beeman's thumbprint was on the tin, as he has been in the flat before to buy drugs, and had handled the tin to place money in it. So let's have a look at the skelly. And the skelly is a submission of no case to answer. And you may think a brave submission, but look how it's presented. And as I say, this was a good effort by one of the youngsters, a bit adapted. I've laid it out as being the Supreme Court of Keble College, Oxford, and the High Court of Justice, as we would say in the local area, in the local region. It's got a case number. It's set out as the case against Wayne Beeman, with the appearance of androgynously a Leslie Jones for the Crown and a Joe Smith for the defendant. Now, I just move this over here. Right. So the first thing we've got is overview. You've got this opening paragraph. Just tries to capture the outline of what this is all about. It's called a defense submission of no case to answer. It's not called a submission of no case to answer. It tells me who's serving this document. I know it's come from the defense. And what is it? It says it's a submission of no case to answer. And you will see as we go through this case, there are lots of details which we refer to, and you won't have had all the case papers. You'll see it's quite a complicated scenario, but you'll be able to follow it. You'll get the point. You'll get the point about the level of detail and the structure of one of these documents. And this is what we'd like to see. Speaking as a judge, this is what I would like to see, and my colleagues would like to see more of. Documents like this. Right. The defendant faces a single count of possession with intent to supply heroin, contrary to Section 5.3 of the Misuse of Drugs Act 1971. That's UK legislation. It'll be different on each of the islands, and it'll be different, of course, on TCI, I suspect. The defendant submit that the prosecution case taken at its highest is such that a properly directed jury could not properly convict. The defendant honour the identification evidence is not only inherently weak and of poor quality, but also contaminated. Further, there is insufficient evidence on which a reasonable jury could, on one view of the evidence, reach an adverse inference against the defendant. The defence invites the court to withdraw the case from the jury and direct a not guilty verdict on the basis of the second limb of Galbraith. So that just sets out an overview as to what we're supposed to be doing. It's the second limb of Galbraith submission where there is inherently weak and poor quality identification evidence and contaminated material. Let's see how it then develops. The next section, we've got setting out the applicable law. But note, if I may say, the meticulous footnotes, which lay out the indictment, reference to case materials, reference to cases, findings of the relevant sections in learned tomes like Archbold or Blackstone's. Now, it may be a bit of a stretch to be asking locally for all these elaborate footnotes, but if you can, they're great. So here we have a pretty good skelly, as I've been saying earlier on. So our next section is the applicable law. And a submission of no case to answer can be made under the second limb of Galbraith, where there is some evidence consistent with the defendant's guilt, but it suffers from an inherent weakness or vagueness. In these circumstances, and we just pause there, footnote number 3, and you see Galbraith, page 127, Archbold 2019, at paragraph 4/364. So we have referenced the law and the legal finding. In these circumstances, the judge is under a duty to stop the case if a properly directed jury could not properly convict on the evidence. Where the issue is whether there is sufficient evidence on which a reasonable jury would be entitled to draw an adverse inference against the defendant from the totality of the evidence, the judge must stop the case where, taking the prosecution's evidence at its highest, a reasonable jury could not reject all realistic possibilities consistent with innocence. All right, bit of a stretch this, nice little point. The argument is being made there are too many other inconsistent possibilities in this case, inconsistent with guilt, to allow the case to go forward. And that's essentially the weakness in this argument. But it's nicely put. The advocate is trying their best to neutralize the competing different directions that the evidence could point. Paragraph 4, in a case that wholly or substantially depends on the correctness of the identification of a defendant, a turnbull direction is required. You've got your footnote 6. If the quality of the identification evidence is poor, such as fleeting glance, the judge should withdraw the case from the jury unless there is other evidence capable of supporting the correctness of the identification. All of this nicely referenced. Good stuff. And then it goes on to say, and having set out the law, it's being said, the second limb of Galbraith applies. Defense submit that the totality of the evidence cannot cure the cumulative weaknesses in the identification evidence such that a reasonable jury could properly reject all realistic possibilities consistent with the defendant's innocence. Taken at its highest, a properly directed jury could not properly convict on the evidence. Okay, so here we go. We set it all up. We've got the legal parameters, and now we're going to delve into the facts. Section 1, the identification evidence. P.C. Sullivan's purported identification of the defendant suffers from the following inherent weaknesses. A, he caught a fleeting glance at the man. He claims the defendant as he opened the door. This man was a stranger to him. The lighting was extremely poor. P.C. Sullivan then loses the man on the stairs, breaking the continuity of sight between flat 6. And when he next sees the men outside, P.C. Sullivan sees the two men from a distance of 20 meters, and in poor lighting, he does not see the faces of both men. B, the physical description of the man P.C. Sullivan saw at flat 6, recorded in his notebook, matches the description given of Derek Hodson by P.C. Griffiths exactly, being over 6 foot tall, stocky build, beard or heavy stubble, early 20s, and had a northern accent. C, there is a material discrepancy between the description recorded by P.C. Sullivan and the actual appearance of the defendant, Beeman, recorded by the custody sergeant at Keble Police Station, being 5'11", proportionate build, in his 20s and moustached. Now, the point here is look at the details. The details of the facts are being offered, the fleeting glance, the inconsistent descriptions, the distances, the lighting, all nicely laid out, referenced in the evidence. Paragraph 7. Chris Simon's purported identification is not only contaminated, but also inherently unreliable for the following reasons. A, Simon was arrested as a suspect in connection with the supply of drugs at Flat 6 after PC Griffiths found his explanation that he was there to buy drugs unconvincing, quote unquote, from the evidence. During Simon's interview on the 2nd of January 2018, the police told him that the man they suspected to be the one that was at the door at Flat 6 was in the same cell block as him. His name began with a B, and he came from the north, making it difficult to understand him. During the interview, Simon was unable to name or provide any description of the man he alleges to have seen at Flat 6. Simon's subsequent identification and witness statement has been contaminated by what he was told by the police. Simon's identification on the 16th of January 2018 came after he was given the opportunity to view the defendant in the cell block, knowing that he was the police's suspect. He has a previous conviction, very helpful, for perverting the course of justice, for falsely identifying an innocent man. Different case. This shows a propensity to falsify and fabricate evidence as well as lie under oath to advance his own interests. As Simon assisted with the police investigation and identified the defendant, he was never charged. Paragraph 8. At its highest, PC Sullivan's identification evidence is of very poor quality, and Simon is a demonstrably unreliable witness. Cumulatively, the identification evidence suffers from fundamental weaknesses. And now we go on to some other material. We divide up the evidence into other sections. Other evidence relied on by the prosecution to support the identification evidence. The prosecutor relies on the fact that the defendant discarded the key to Flat 6 when he ran from Perrywood Walk to corroborate the identification evidence. PC Sullivan has accepted an evidence that he saw something passed between the two men on the pavement, but could not see what. The defendant is not forensically linked to PCG1, which is the package containing drugs discarded by Derek Hobson. As such, a reasonable jury could accept the realistic explanation that the defendant was passed the key. Further, the prosecution relies on the fact that the defendant's fingerprint was recovered from the lid of the tin box containing the cash found inside Flat 6. This is a movable object, and the forensics match must be put into its proper context. There is no other forensic evidence linking the defendant to Flat 6. The defendant did not provide an explanation for his fingerprint in interview, but an adverse inference is restricted to a fact relied on by a defendant in his defense as opposed to his failure to explain a fact relied on by the prosecution, and therefore it cannot be used to establish a case to answer. Pretty brave, but nicely put. Paragraph 11, the defendant's previous convictions for the supply of heroin are capable of being used as evidence of propensity to commit the offence charged. However, in cases that turn on the correctness of the identification evidence, previous convictions cannot be used to bolster weak identifications. Footnote 21, and there is reference there to a number of cases to support that very important feature. And then the final paragraph, other evidence capable of undermining the identification evidence. The evidence as a whole must be assessed to determine if there is a case to answer. Other evidence that must be considered includes the package discarded by Hobson. A man who cannot be traced contained heroin deal bags that match the purity level, 28%, the appearance of the bags and the value of those found in the rucksack in the bedroom of Flat 6. The description of Hobson provided by Griffiths matches the description recorded by Sullivan of the man he saw at the door of Flat 6. Reasonable jury should accept the realistic explanation the defendant has been mistakenly identified. B. Sullivan confirmed that the police had intelligence that drug users purchased drugs at Flat 6 and on Perrywood Walk. A reasonable jury should accept the realistic explanation that the defendant was present on Perrywood Walk to buy drugs. Conclusion. Finally, wrap it all up. The defence submitted paragraph 13 on the basis of the second limb of Galbraith, given the confusion what P.C. Sullivan saw, inconsistency in what description fits who was at the door, the unreliability of Simon, and the existence of plausible reason for the fingerprint, therefore not pointing only to guilt. A properly directed jury could not reasonably convict on the evidence taken at his highest, and the case against the defendant should be withdrawn from the jury at this stage. And then you see it is named. We've got the name of counsel. that it's defense counsel, and there's a date. I often find I get documents which have got no names, dates, or anything on them. So there you have what is an example of a reasonably good Skelly. It runs to about 4 pages. It identifies all the relevant material, and it weaves it together as laying out what the facts are, commentary on why the facts don't then meet the standard which has been articulated in the second limb of Galbraith. And it all is tied up in a nice little bow at paragraph D, conclusion, and in you go to court, and you blend your submissions using your skeleton as a map, and you work what you say to the judge with what you have written for the judge, referring the argument to the judge as written, as you are addressing the judge orally. Now, I've given you an example, therefore, of a good Skelly, and that, I hope, will put in your minds what it is that it looks like. Now, I'm just going to stop the share, and I'm going to go back to sharing the PowerPoint. And we now go, I think, to the last of the slides, and that is review. And I'm hoping that that is on your share screen in front of you. What have we done? We've had a look at the importance of the 3 E's and the 3 I's: invisibility, integrity, and irresistibility. Guard your integrity, because persuasion revolves around it. Help, don't push. You're there to help the court. Don't make the judge look daft. And a skeleton is short. It's a map as you speak, setting out the best points, matching the facts of the law, and answers the other side's best points. So now, I hope in what I've done, you've got a pretty good overview as to what a skeleton should look like, a written submission supporting argument in a criminal case. And with that being said, that brings the PowerPoint to an end. That brings the example of the skeleton argument to an end. And I think we've got about 10 minutes for questions, because we started at 10 minutes past 10, so we've got a bit more time. So I hope that's helpful. And I turn to you, Mr. Emanuel, for any questions. I'm hoping that was of some interest to those who've gathered.
Morley, thank you for that very informative presentation. So we'll now open the floor for questions.
My first question, if I may, and I'm not going to come on screen because it's Saturday. I've just come back from walking my dogs. Ian, can I just ask you this? That was a very good skeleton argument, and I'm just wondering for the advocacy training part of this as to what you really would want to be saying in court. Has your lordship read the skeleton argument? Have you picked up the various, whatever those points are? And that's it, isn't it? I mean, why would you want to talk through something which is already well set out in a short, concise skeleton argument?
Because the judge may not have read it.
And you think the judge
may not have read it thoroughly.
Ooh.
So you always want to take the judge through the document. So who's addressing me? Hello, I can't see who you are. So hello.
Sorry, it's Andrew Mitchell. I said that I wasn't going to come on the screen because I'm not appropriately dressed for court.
Oh, I see. Sorry, Andrew. I didn't see that. I can't see your what is the word? Your Zoom screen flashing.
Nomenclature. Okay.
Right. Okay. There we are. So hello, Andrew.
All right.
So,
hi. I mean, if the judge says I've read it, you've told us the judges are, and we must take them at their word. What is to be gained apart from perhaps frustrating the judge by then taking them through that skeleton argument?
Well, okay. A bit of judgment here, as you know. There are some judges who, when they say they've read it, they really have.
Yeah.
And there are other judges who say when they've read it, they may not have done. and they may not have done as thoroughly as you would like. I mean, I would certainly say, if I was on my feet, I'd say, well, thank you for that indication, Your Lordship. May I just invite consideration, please, to some of the factual features in the case. You will see from the beginning of the document that it sets out what I'm trying to achieve. And I'm saying this is the second limb submission. And I've laid out the law, which I know Your Lordship is familiar with and has read. But may I just take a moment to work with Your Lordship on the factual features? And although they're all set out on the document, it may be that the way in which I can articulate matters puts a different emphasis on how Your Lordship approaches these materials. And if I may remind the court, therefore, of the following factual events that took place in the trial. I'm looking now at paragraph 11 or 8, I can't remember which. And I invite Your Lordship's attention to that. You'll very quickly learn whether the judge is saying to you, I read all of that, go away. Or what normally happens is a matter of human interaction. If the judge has read the material, they will be encouraging of the fact that you have drawn their attention to it. And you will get an idea as to whether the judge is with you or against you. If you then feel that the judge is against you, then maybe it's time to be a bit tedious and push it. But if you have the impression as a matter of judgment that the judge is with you and is saying, well, actually, I've looked at all this material, I've seen some of these points, some of these are good points, and I'll be talking to the prosecution about this. I don't think you need to develop the point further at the moment. I'll hear from the prosecution and then come back to you. Then if you get that sort of response, having pushed a little bit, then you might sit down. But my experience is that in most cases, the judge will let you run with the skeleton because it may not have been studied, may have been glanced over, it may have been read quickly, but it may not have been studied. And I'm sure, Andrew, you've had this experience as well, because you've been around the block as I have. And I'll bet you've been in front of judges who said they've read it and they haven't really. What do you think?
Absolutely. Of course I have. I've also been in front of judges who say, I have read it, 5 minutes, what have you got to say?
And then you run with the personality you're in front of.
Yeah,
and part of the art of the advocate, and this is a seasoned advocacy and experienced advocacy training point. It's the ability to weigh the personalities of the people you're working with.
Absolutely.
And we all know that you've done a lot of the work, so you'll know how to weigh the personalities. But for the youngsters who are starting out, I think the thing is try and get the judge to pay attention to the skeleton as you're making your submission. So, any other questions? Anybody, Mr. I know Mr. Cruddow is in the audience. I don't know if he's got anything to ask. And I don't know anybody else who's amongst those who gathered. Any other questions?
I have a question, Judge. Yes. And obviously a career ambition of mine remains to make Mr. Mitchell look good. So on behalf of the leader, I'd thank you for your comments. I have a question, sort of a point. I have two quite junior colleagues with me. Would you agree or have a view, if you don't agree, that even if perhaps your more senior adversary decides that he or she doesn't need a skeleton, that it's still worth putting one in, even if you're not asked by the judge, but you feel on firmer ground if you do put one in? And then related to that, obviously present company accepted, if you were to come before a robust judge who tells you to sit down because they have all of the information that they need, to what extent do you make things worse if you don't sit down and you keep going?
Well, okay, dealing with the latter first, a question of judgment, isn't it? If you've got a judge who's ordering you to sit down, well, it's a bit of an unusual circumstance arising. But if you've got a judge who's ordering you to sit down, and you haven't said anything yet, you simply stood up to say, well, I wonder if your lordship has seen the skeleton argument. Can we look at it together in the courtroom as it pleases your lordship? And they order you to sit down. Well, it may be it's time to start getting some things on the record for the appeal that's going to follow. So you might want to push it just in order to have what you want to complain to the Court of Appeal about.
Well, I mean, sorry, I beg your pardon.
As for the earlier question, which is, do you write a skelly even if your leader says don't? Well, I was.
No, I wasn't, Judge. I wasn't saying that. I was saying it wasn't a leader. I was saying if your opponent is even perhaps significantly senior to you and they show no sign of doing that, are you right to plow on and put one in yourself?
Oh, yes. Yeah, because it shows the court that you're really keen. And it shows, therefore, that you've got a lot to say and that you're worth listening to, and you've given it a lot of thought, because otherwise you wouldn't be writing stuff down and putting it in the documents. And it therefore lends the impression that you're reliable and you're somebody who should be listened to. And if you then listen to, you're more persuasive than your opposition. It does strike me that if one side is putting in a skelly and the other side isn't, the other side's just being lazy. And that will generally be the impression which is created. And you get brownie points for putting in the skelly, and you make the other side look like they're not really on top of their case. Even if the argument isn't the best argument in the world, it still makes it look as if you have got the better position than the other side if they're not working it. So that's my view. That's what I would do if I was practicing. I did practice for a long time. I would put in a skelly, and I'd be delighted if the other side didn't. I'd be positively whooping if the other side did not put in a skelly, because I would think I'm in charge of this argument now. And the judge will probably think that I'm in charge of the argument as well. Does that help with the answer?
Yes, it does. And in fact, what you don't get to see is I don't think I'm the only person here physically who's had the experience of a judge saying, yes, thank you, sit down. I think several of us have had quite scant opportunity to expand on what we have on paper. And I do, if I may say, agree that you pivot then and start to think of a transcript and what's appearing on your transcript.
Yes, and I know you do, Mr. Prideaux. You're a very forward-thinking advocate, and you're made appearances in front of me. And that's the way to do it. Be thinking of everything, not just what you're arguing in front of this judge, but what you might have to argue later. So, yes, thank you. Any other questions?
Judge, we have no further questions.
Well, I hope that's been of some use, and I hope that you've got an idea of structure of arguments. I know Andrew Mitchell will know, and I know Mr. Tim Prideaux will know what skellies look like. That'll be the bread and butter of work that they'll have done in London context. And I'm just hoping that those who are more local to the TCI have now got a better understanding. And I would suggest respectfully that the work of people like Andrew Mitchell and Mr. Prideaux, and I think Jerome Lynch is over there as well, and maybe others too. If you're doing skellies, let the juniors, the bar, get some idea as to what they look like, so that they're able to learn from you. You're pretty experienced counsel, and I suspect that the talk would have been possibly more effective coming from both of you than from me. Some people might say, oh, well, he's a judge, what does he know? But the advocates who are at it, they'll know what it is to be working daily on putting in skeleton arguments. So can I thank you all in TCI? It's interesting to see you all. A good friend of mine used to be a judge there, Shiraz Aziz. And I hope you're all having lots of fun in TCI. I am going to remain in the background just to listen to the presentations for a bit. And unless there's anything further, Thank you, Mr. Emanuel. I'm just going to go to blank mute.
Thank you, Justice Morley, on behalf of the Judicial Education Institute, and we'll thank you more formally at the end of the proceedings. So now I'd like to hand over to our local counsel, Ms. Lara Maroof and Mr. Oliver Smith, KC, who will provide their insights. So good morning.
Good morning, everyone. Myself and Oliver Smith, King's Counsel, decided to do a collaboration. So we're going to present jointly to you that because the title of the seminar was Skeleton Arguments and Written Submissions in Criminal Trials, we, as Justice Morley has spoken in detail about skeleton arguments, we didn't want to bore you by going through similar points. And so we've decided to speak about written submissions as distinct from skeleton arguments. And I'm going to try to share my screen as well. I think that's worked. So the title of our presentation is Written Submissions in Criminal Trials. And I'm going to turn over to Mr. Smith.
Thank you, Lara. That was a very good presentation, Judge Morley, and I'd like to thank you on behalf of the local bar for taking the time out to educate us on that issue. I'd like to start off by just highlighting what I submit are the differences between skeleton arguments and written submissions. Personally, I come from a point where the written submissions, I use it as an analogy to during my practice in New York, where you get very limited time to present your applications in court. As a matter of fact, when you're making an appellate application before any other court of appeals, whether in the state court or in the federal courts, there's a time limit. So in the United States, there's a heavy emphasis on detailed written submissions. When you appear in any of the appellate courts, there are a traffic light, similar to traffic light, with a red light, a green light, and an amber light. When you initially file your brief, you're given a certain amount of time to make your presentation. So that requires full submissions. The green light tells you when your 10 or 20 minutes starts. The yellow light tells you have a minute left. And once a minute left, the red light comes on and your mic is muted. And the time is not extended even if there's colloquy and questions from the bench. So the written submissions are full submissions, laying out in detail what you want to say to the court. So in making your written submissions, do it from a focal point that this is maybe the only opportunity you're going to get to address the court. And you have to make sure that it is very detailed. Now, a skeleton, as the learned judge just indicated, can be used to outline your oral submissions to the court, but written submissions will often be your entire submissions, and the court will not expect further lengthy oral submissions. In the courts in Turks and Caicos, there is been a move towards full written submissions over skeletons, particularly in the Court of Appeal, and I believe Justice Morley highlighted that we see very little use of skeleton arguments in this jurisdiction. It's more an emphasis on full, detailed written submissions.
So what are the benefits of written submissions in court? Well, it provides the court with your complete arguments and your analysis of the case in one package. And you filed that in advance of the hearing. You hope if the court has asked for written submissions rather than a skeleton argument, that your judge or judges, if you're in the Court of Appeal, have actually read it and have a full grasp of what your argument is before the court hearing date, before your hearing even begins. It's beneficial because it provides the court with ready access to the authorities, whatever they are, case law, legislation, journal entries. And you can also, you should also include the relevant extracts or the paragraph references for the court, and they are able to cross-reference with your authorities bundles, and should have done that in advance of the hearing. And the benefit, of course, is as well that it limits the amount of time spent in court, which is even more of a consideration these days than it has been in the past. The courts are busy, the courts have limited time. So if you're able to put your arguments in writing in advance, you then are going to have a shorter court hearing, and the court will in fact expect that to be your full submissions, and perhaps only if there's anything additional you want to tell the court at the hearing, or perhaps to answer your opponent's submissions. Another benefit of written submissions, because they are full, is that the court can use those submissions to draft their judgment. And in recent times, I think certainly I've had the experience, I think Mr. Smith may have had the experience, that the court, if you've sent a PDF document, the court is coming back to you asking for Word to help save your judge time, because he's going to quote parts of your written submissions in his or her judgment. And so when it's in Word, they can just cut and paste, and you've saved the judge some time with his or her typing. And that, all of that, of course, helps to contribute to what we can call judicial economy.
Now, in addressing what type of applications require submissions in criminal trial, it requires a lot of forethought by the advocate. Approaching a case, you must have an idea of what your end product is going to be. And my mentor always told me, and I've used that in my practice, is that you approach your case as to what you want to say to the judge or to the jury. So your questions, your submissions, your initial applications has to be with that particular focus as to what is the end product. So there are in limine applications. You get the brief, you get your instructions, and you have to address your mind as to what applications I need to make prior to the commencement of the trial. And those applications can be included in a full written submissions. Just speaking off the cuff, you may have an issue in relation to the jury, to the location of the trial, the venue of the trial. We don't have that as much in this jurisdiction here, but in other bigger, larger jurisdictions, you may want to try the case in a different venue. So there may be an eliminate application for change of venue, because the venue where the incident occurred or where the crime is alleged to have occurred, you may believe that you will not get a proper and fair jury pool. So that particular topic could be the subject of an eliminate application that requires full written submissions. Applications to exclude evidence. Now that can either be pre-trial or during the course of the trial. And in sometimes these applications are applications that could result in the end of the case at all, totally. If the only issue in a case is in terms of identification, and you believe that the identification procedure, initial identification procedure is improper, you may want to make a full written submission, because if successful, that could be totally dispositive of the case. What other options? Applications for severance and joinder. Means severance in terms of not only counts, but severance in terms of defendant. You may be going to trial, especially in a small jurisdiction like ours, with a defendant who has a long history of violence or gun history, and this is your client's first time with any type of those charges. And you may need may need to think, listen, I don't want to go to trial with this young gentleman because it may prejudice the jury because, you know, show me your company, I show you where, show me the company you keep, I show you who you are. So you may want to make a full written submissions in relation to that. An application for special measures under, we now have a vulnerable witnesses ordinance, and those applications can be the subject of full written submissions. And of course, submission of a no case answer. We just saw a skeleton version of that from Justice Judge Morley. Sometimes, especially in this jurisdiction, you may want to make a more fuller submission in relation to that. Oh, yes, and submissions and sentencing. I neglected to address that. That is critical, especially in a jurisdiction like ours, where we are just now developing sentencing guidelines, and we do have a route to sentence and set precedent on sentence in relation to our jurisdiction. So submissions and sentencing in this jurisdiction is very, very critical, and I believe should be the topic of containing in full written submissions. In those submissions, on sentencing, you want to address the whatever possible sentencing that was done in prior cases. If you, in our jurisdiction, you want to look as well as the overseas jurisdictions in the UK as well as in the Caribbean Commonwealth jurisdiction.
So how should you lay out your written submissions in a criminal trial? Again, similar ingredients, I think, to the skeleton argument, but in more detail. So again, you start with your introduction. You need to say in a nutshell in the first paragraph what it is that you are asking for. So when the judge reads it, he knows, he or she knows. The facts or summary of the evidence, that can be quite detailed, obviously only putting in what's relevant to your application. But these are full written submissions. You can really set out in some detail the history in relation to your application, whether it's events or evidence, when evidence came to light. Chronological order, I think, is favored by the court. Make it look very clear. You can highlight the dates so that it's clear to your judge. You need to have a section setting out the applicable law, give the full citation of cases. Again, even though these are written submissions rather than skeleton, you wouldn't want to be cutting and pasting large pages worth from case authorities, but the relevant paragraphs you could include, or a paragraph, and then of course you attach the full authority in your authorities bundle. And that's the next point. You append to your written submissions your authorities, and you would make sure that you include the relevant page reference or extract just the key paragraph for your judge to read as she's going through the written submissions, and she can see it's you're leading your judge into your argument. So the judge has read about the law, read the facts, and then you go into your argument, looking out in a logical fashion, applying the facts in the particular case to the applicable law or vice versa. And there is some discretion there as to how you set it out, depending on what the application is. It just needs to make sense. And as Justice Morley indicated, with oral advocacy, as with written advocacy, you're seeking to persuade your judge to grant your application to your point of view. Some tips for how written submissions should be laid out. Of course, strive for clarity. You don't want your judge to be reading your submissions, spending longer than necessary trying to work out exactly what you mean. So not using too many words, using clear words, aiming to be coherent. I think is a similar point. Make it clear what you're saying to your judge. Always an important point, and I think Justice Morley emphasized this, think about how, before you even get your response from your opponent, think about how your opponent is likely to try and answer your points and try and weave into your own arguments a response to that. Anticipate and address those arguments. And then at the end, in your conclusion, you reiterate in a strong fashion as possible, whilst still being polite, what it is that you're asking the court to do, so that the judge is clear. And you end, of course, your written submissions, as with skeleton arguments, with your name and the date, so the judge knows who the submissions are from.
As with everything, there are pitfalls and stuff that you need to avoid when drafting your written submissions. And the first thing is that even though it's detailed, even though the written submission is required to be detailed, it should not be overly lengthy. The danger for that is that the judges are persons who have many different matters to deal with on a daily basis, and you need to hit your points, hit it in a detailed fashion, put the meat on the bones, but not be over lengthy. And close to that, walking hand in hand with that, is that there's no need to be over elaborate. There's no need to keep repeating a point over and over again. The judges get it. They'll get it from the first time. And if they don't get it from the first time, when they go back to the comfort of their chambers and reviewing the skeleton submissions, they will get it. So there are no need to keep repeating and to be over elaborate. And avoid being verbose. I find, and most judges find, that clear, simple language is the best form of communication in your written submissions. There's no need to test the judge's vocabulary and to have him resort to his dictionary. Just be clean, clear, and avoid verbosity. Avoid storytelling. Some lawyers believe they're great fiction writers, and you'll find yourself sometimes trained within the realms of florid language. It doesn't work in these situations. It distracts the judge. The judge, as I said, he's got a lot of stuff to do. Hit your points, hit it very clearly. Leave the storytelling when you're on your feet before a jury. I mentioned avoiding repetition, and do not include voluminous extract from authorities. You can reference the authority and the relevant page, relevant paragraph. You could edit the particular language that you want to use, but there's no need to include these voluminous extracts. Hit the pertinent points. And very telling, avoid the use of Latin phrases unless it's really necessary. If you are dealing with a criminal case as this is about, and the Latin phrase actus reus, mens rea, those are phrases that are necessary. But you don't need to walk into the realm of ex abundanti, cautela, and all those kind of stuff. It doesn't help your submissions.
So that's what we wanted to speak to you about in relation to written submissions. We did provide. No, I don't think those are. I think that's it. Stop sharing. Oh yeah, that's true. Pause share. No, stop. Okay, we've managed to stop sharing. We did provide to everyone a sample case of the King and Joe blogs in the Supreme Court of the Turks and Caicos Islands. I don't know if everybody had a chance to read through those. What we had intended to do was to run through, give you a chance to read through those, and then put together written submissions. We had a sample written submission. So what we could do is I can share my screen to show you the sample submissions that we put together, which are similar, in fact, to the skeleton argument that Justice Morley showed, and shows you really sometimes the fine line between a skeleton argument and written submissions. I don't know if having looked at the written submissions, can anybody did anybody anticipate what sort of application we would be making? Well, it could be an application to exclude the evidence. We had in mind a submission of no case to answer, because we've reached the point in the case where the evidence has been adduced, and we've got to the end of the Crown's case. And so, although it all really is relating to identification evidence, we're at the point of the case where the evidence has come out, and so we are hoping to make a submission of no case to answer.
The facts of our case on the screen. You guys see that in your screen? Just read through it very quickly. The case is being tried. Case of Rex versus Joe Bloggs. Bloggs is being tried at Supreme Court before judge and jury. Charged with robbery of the 10 hour downtown public college. Prosecution has called all of the witnesses. Evidence that has been called for the jury as follows. Number one, Ms. Lovely. The night of the 1st of April, Ms. Lovely was working at the bar. Around 11 p.m., a man wearing a mask which covered all of his face except the eyes in the bar. He had a gun in his hand and shouted, "Give me all the cash."
Pardon me. I'm unable to hear the presenter. Can you please use the mic?
Thank you.
Thank you,
Is this
Mr.
any better?
Yes, that's
Is this any
better.
better?
Yes, that's
Okay.
better. Thank you. Mhm.
So I'll start with witness one again, Ms. Lovely Stubbs. On the night of the 1st of April, Ms. Stubbs was working at the bar. Around 11 p.m., a man wearing a mask which covered all of his face except his eyes came into the bar. He had a gun in his hand and shouted, "Give me all the cash and phones." She was so scared, she opened up the cash register and gave him all the money in the register. The man went around the bar, but taking cell phones from everyone present. He then fled from the bar on foot. The robbery lasted no more than 2 to 3 minutes. Her description of the robber was a black male, at least 6 feet, wearing a mask. The second witness, Mr. Frankie Smiles, his testimony was that he was at the bar on the night of 1st of April. He had been there for about an hour before the robbery occurred, having some drinks and making friendly banter with the staff. When the robber entered the bar, he heard the male say, "Give me all the cash and all the cell phones." He was in fear, so he put his cell phone on the bar and closed his eyes. When he heard the robber speak, he thought the voice was familiar. After the robbery, he left the bar and the police came, and he had decided that he definitely recognized the male as Bad Joe from the bites. He didn't know Bad Joe's full name, but he knew he was always in trouble, and his voice sounded just like the robber's voice. He had spoken to Bad Joe about 2 or 3 times before when he had been hanging out in the bites. When he spoke to him, they had just greeted each other by saying, "Hey, what's up?" or something like that. However, he was very familiar with what he looked like. And the police officer, investigating officer, police constable Stitchup, was assigned as the investigating officer. He was informed that Bad Joe from the bite was a suspect for the robbery, having been recognized by one of the witnesses. He was familiar with that name and knew him to be Joe Bloggs, who lived in the Mama's Yard in the bite. On April 2nd, he arrested Joe Bloggs at his home in the bite. His home was searched, but nothing of any evidential value was found. He was taken to the police station and later charged with robbery of the $10 bar. He confirmed that Joe Bloggs is a light-skinned black male, about 5'1" in height. with those facts, at the end of the prosecution's case, what do you guys believe the written submissions would be? What are the issues? Anybody?
Good morning. I think one of the issues is the voice identification.
Yes.
So the defense attorney will be making an application to basically exclude that evidence. The voice identification isn't as reliable. So I think that's one of the applications that will be made.
Well, the evidence is already in, so it's late to exclude it. But it can be used as a fact in a particular application that you can make at the end of the case.
Okay.
Yes, there's a discrepancy in the type of the nature of the description, identification evidence given, yes. Yes. Our view is that the factors here and the evidence as is would be ripe for a no case submission application. Ms. Maroof?
So I'm going to share, we drafted something in between, I think, a skeleton argument and written submissions. So I'm going to see if I can share that with you. So this is the skeleton argument which Mr. Smith, King's Counsel, and I have drafted based on this case, where as Leanna Brooks indicated, on the facts, potentially, counsel could have made an application earlier to exclude the voice identification. But for counsel's own reasons, she didn't. She's waited until half time, and she's going to make a submission of no case to answer on behalf of her client, Mr. Joe Bloggs. So he's set out there, as we discussed earlier, what's your application, the introduction. This is a submission of no case to answer on the ground that there's no evidence upon which a properly directed jury could safely convict. So you told the judge in your introduction what your submission is, what you're asking for. The law, here we set out the law very briefly. With criminal judges, they're very familiar with submissions of no case to answer. The law is well known, so we don't need to go into too much detail, but we reference there, as far as the no case submission is concerned, we're relying on the case of Galbraith, very well-known principle, and we've quoted directly from the authority. Ooh, something. All right, technical issue. Okay. But we've also then included identification evidence, because this case clearly is an identification case. In fact, it doesn't seem that there's any witness saying that they can visually identify the robber as Joe Bloggs. It's a voice identification case, which are becoming, I think, a bit more seen in the courts. Mr. Smith and I had a case together that relied heavily on voice identification. And we still refer to Turnbull, so they're under identification evidence. Again, very familiar to criminal practitioners, criminal judges. The quote from the well-known case of Turnbull, which is still applicable in relation to identification generally. And then voice identification, letting the judge know there, again, fairly briefly, the relevant authorities, which will be appended in an authorities bundle, the case of Crow, and another case, Flynn and St. John, which makes the point that voice recognition is actually more difficult, has been shown to be more difficult than visual recognition. So that was the relevant law. We then moved on to the facts, or in this case, really the evidence, because in a submission of no case, you're going to want to review for the judge, well, in summary, and what's relevant to the submission of no case, this is the evidence that's come out. It may not be accepted, but taking the prosecution case at its highest, which is what you're doing with the submission of no case, this is the evidence at its highest against this defendant, poor old Mr. Joe Bloggs. And so we set it out very briefly. This is the evidence that's come out. And then the submission, there are arguments. The only evidence at paragraph 8 against the defendant is the purported voice recognition evidence, applying the guidance in the case and setting out why it is that in this case, the voice recognition evidence is clearly of very poor quality, and the reasons are set out there. The limited time which the Frankie Smiles heard the robber's voice, limited previous interactions with the defendant, and unable to identify anything distinctive. So it's fairly briefly set out. And I think probably with this kind of written submission, you would expand a little bit in court, as it's perhaps closer to a skeleton argument than full written submissions. And having set out our arguments, then at the end, again, strong conclusion, there is no case to answer, and the court should, not must, but should withdraw the case from the jury at this time. Dated, signed by learned counsel, and that is another example for you of a sort of skeleton argument that you might put forward in a criminal trial.
Unless you have any questions for us? Yes.
In England, as Lara will remember. Oh, sorry. Yeah. It may seem a little bit self-serving or mercenary, but it's a relevant question. If you're on a legal aid certificate, obviously we understand the difficulty about being on the legal aid certificate, but there's no financial incentive for you to write a skeleton argument. Or put another way, you don't get any more money for writing one, do you?
No.
See, in England, as again, as Lara will know, there are bits of money, if you could call it that, for a skelly. There's nothing here, is there?
When I was in England, with definitely under the system for most cases, it's like a fixed fee. So that's similar to what we have here. So you're not, whether you did a skeleton argument or you didn't do a skeleton argument, you're going to get paid the same. Yeah. So you do it to improve your argument, and just with the hope of putting forward the best argument, getting the judge to understand what you're saying in advance. But so, and over and above that, even if you weren't motivated, often now the judges are requiring more and more here for every application, written submissions in advance, always for sentencing now, because sentencing is not considered straightforward. So before the sentencing hearing, we're being asked to file submissions, Crown respond, and sometimes reply to their response. So there is quite a bit of work involved.
Yeah, and just to add what Ms. Maroof says, as counsel, you have an ethical obligation, regardless of whether you're being paid or not, to put your best foot forward for your client, for your indigent client. And that's if it involves making skeleton arguments or making full submissions, you should do that. Moreover, the new criminal procedure rules now essentially mandates that most, if not all, applications should be made in writing, unless the court orders otherwise. So it's your best foot, putting your best foot forward, but at the same time keep acting within the dictates of the rules.
The other interesting thing amongst your very useful talk was the the idea of keeping hold of a Word version of your materials.
Yes.
In fact, in the civil version of this the other day, I said precisely the same thing. And obviously I have two colleagues behind me who know that I obsess about the date and the version number and always finishing with exactly the same Word document as you've turned into a PDF for precisely the reason
Yes.
you talk about. The last thing you want to be doing is fishing around on your laptop, trying to figure out whether the PDF one was in fact the same one. It's terrifying.
Yes, yes, yes.
So I'm glad to hear others say it's a must.
It's critical, and more judges are requesting it, because it helps the judge. Because remember that our main function is to assist the court, not only when you're on your feet, but when you're in office to provide them with whatever documents they require.
It can give rise to a wry smile occasionally. I mean, I've had reserved judgments that have been reserved for a very long time, and then you get a request for a skeleton argument. It's difficult not to draw the inference as to when they were working on the reserved judgment.
Manuel, I'm not sure if there are any other questions.
Hi, morning. Kimon Tennant here. I have a question, please. Firstly, very good and very informative and interesting presentations from all the presenters. But just to touch on an area that I think Ms. Maroof alluded to, where you have familiar authorities, how should we as advocates treat with those in our skeleton submissions, written submissions, and even on our feet? Should we go through them in detail or just gloss over them, for example, a Galbraith or a Turnbull?
Like, do you mean like the classic cases?
Yes.
The classic authorities, right? I think certainly if you have an experienced criminal judge, the basic principles are really well known. I think it's always worth emphasizing them, even though you know your experience. It's always good to read through them again. But I don't think you would need, certainly with something like Galbraith, Turnbull, to go through the actual authority unless there was a particular distinct point within the facts of that case that you wanted to bring out. But the principle is so well known, I think you could just reference the name of the case and the principle, and that would, I would think, would be sufficient.
Yeah, I agree with Ms. Maroof. You always still in your written submissions, whether it's skeleton or your full written submissions, you always put the reference, and I would urge and encourage that you cite the particular dicta that you're referring to. Now, normally, when you're on your feet, you will say to the judge, I've cited Judge Turnbull, which is the case that the court is well familiar with. Unless the court wishes me to take you through the details of what I've written in my submission, I will move on. And most judges who are familiar with Turnbull will encourage you to move on.
Thank you.
Welcome.
Right, so good morning once again, everyone. So this is the last call for any questions from our online audience. Thank you. And if there are no further questions, I'd like to thank Ms. Oliver Smith-Casey and Ms. Lara Maroof for that presentation. And I'd like to hand over to Ms. Tanya Carter, the Executive Director of the Office of the Chief Justice, to give a formal vote of thanks. Thank you.
Hi, good morning, everyone. So on behalf of the judiciary and by extension, the Judicial Education Institute, I would like to say thank you to Justice Morley, who I believe is still with us online, to Mr. Oliver Smith-Casey, and to Ms. Lara Maroof for what was a very informative, easy to follow presentation by everyone. For someone who is not, or who has not prior to coming here had a criminal background or criminal experience, I found each presentation quite digestible and easy to follow. So thank you very much. To the members of the bar, both in person and online, we say thank you for your attendance, and we look forward to seeing you at many more. Again, thank you, everyone. Thank you for your time. To all the presenters. And on behalf of the judiciary, the Honorable Chief Justice as the Chair of the JEI, and Mr. Antonio Emmanuel as the Secretary of the JEI, we say thank you and enjoy the rest of your day.